Hello and welcome to Nova Real Estate Solutions. I'm Dwight Morris, a certified divorce specialist at Innovation Properties in Fairfax, Virginia. Today I'm going to tackle a really crucial topic for anyone going through a divorce here in Virginia, especially when real estate is involved: equitable distribution. You might have heard terms like community property floating around, but Virginia operates under a system called equitable distribution. Understanding the difference between these two methods of dividing marital assets and how it applies to your home is absolutely vital for navigating the divorce process fairly and protecting your future. Now, what exactly is equitable distribution? Well, unlike community property states like California, where assets acquired during the marriage are typically divided 50-50, Virginia law dictates that marital property will be divided fairly, though not necessarily equally. This distinction is really important. The court's goal isn't simply to split everything down the middle. It's to reach a resolution that is just and equitable, considering the unique circumstances of your marriage. This means the court will look at a range of factors when deciding how to divide marital property, and your home, often being the most significant asset, will receive close attention. Let's delve a little deeper into each of these factors to really understand how they can influence the outcome. The court will consider both monetary and non-monetary contributions each spouse made to the well-being of the family and the acquisition and maintenance of marital property. This isn't just about who earned more money. For instance, if one spouse stayed home to raise children and manage the household, allowing the other to focus on their career, that contribution holds significant weight. Similarly, if one spouse actively managed renovations on the home, even using marital funds, their effort and involvement will be considered. We're talking about the whole picture of how each person contributed to the marital partnership. The length of your marriage plays a significant role. In shorter marriages, say under 5 years, the court might look more closely at what each party brought into the marriage and try to restore them to a position closer to that. However, in longer marriages, 10, 20, or even more years, there's a greater presumption towards a more equal division, recognizing the intertwined nature of the couple's lives and finances over that extended period. If one spouse is significantly older, has chronic health issues, or faces mental health challenges that impact their ability to earn or care for themselves, the court will take this into account. The goal here is to ensure that neither party is left in a precarious situation due to factors beyond their control. For example, if one spouse sacrificed their career to care for a sick family member during the marriage and now has limited earning potential due to their age and lack of recent work history, this will be a serious consideration. While Virginia is primarily a no-fault divorce state, meaning you don't have to prove wrongdoing to get divorced, evidence of fault, such as adultery, desertion, or cruelty, can still be considered by the court when determining equitable distribution. This doesn't automatically mean a 50-50 split is off the table, but it can be a factor that influences the court's decision towards a more significant share for the non-faulting party. It's not just about assets. The court will also look at who is responsible for the debts accumulated during the marriage, such as mortgages, car loans, credit card debt, and other financial obligations. The equitable distribution will aim to allocate these debts fairly, often considering who benefited from the debt or who has a greater ability to repay it. The potential tax implications of the property division for each party will be taken into account. For example, transferring ownership of the home might have different tax consequences for each spouse. The court may try to structure the division in a way that minimizes the overall tax burden or considers who will bear the brunt of those taxes. If one spouse has significantly lower earning potential due to factors like lack of education, limited work experience, or health issues, the court might award them a larger share of the marital assets to help compensate for this disparity and ensure their future financial stability. If one spouse, financially or otherwise, supported the other's education, training, or career advancement, leading to an increased earning capacity, the court may consider this a contribution that warrants a greater share of the marital assets for the supporting spouse. If one spouse used their separate premarital funds or inheritance to make a down payment on the marital home or fund significant improvements, they will likely receive credit for that initial contribution before the remaining equity is divided as marital property. This recognizes the distinct nature of those separate funds. As you can see, it's a very nuanced process. The court has a lot to consider to ensure a truly fair outcome, looking beyond just a simple split. Now let's specifically talk about how this applies to your home. Your marital home is often the most valuable and emotionally charged asset in a divorce. The court will need to determine whether it's considered marital property, separate property, or a combination of both. Marital property is generally defined as any property acquired by either spouse during the marriage, from the date of the marriage until the date of separation. This typically includes the home if it was purchased after you got married, regardless of whose name is solely on the title. Even if one spouse's income was primarily used, if it was earned during the marriage, the asset acquired with it is generally considered marital. Separate property includes assets owned by either spouse before the marriage or received during the marriage as a gift or inheritance intended solely for that spouse. If you owned your home before the marriage, it's generally considered separate property. However, as I'll discuss, that's not always the end of the story. However, even if a home started as a separate property, it can become commingled with marital property over time. For example, if marital funds were used to pay the mortgage, make significant improvements like adding an addition or renovating the kitchen, or if both spouses actively contributed to its upkeep through their labor and effort, the increase in value during the marriage, or even the portion of the original equity, could be considered marital property, subject to equitable distribution. It's like mixing separate ingredients into a marital cake, and the ending result has contributions from both. So how might the court decide what happens to the marital home in a Virginia divorce? Here are some common scenarios. The most straightforward option is often to sell the marital home and divide the net proceeds equitably between the spouses, based on the comprehensive set of factors I've discussed so far. This might be the most practical solution if neither party can comfortably afford the ongoing expenses of the home on their own, or if it's deemed the fairest way to liquidate a significant asset and allow both parties to move forward financially independently. One spouse may be able to keep the home by buying out the other spouse's share of the equity. This typically involves a professional appraisal by a neutral third party to determine the accurate fair market value of the home. Once the value is established, the other spouse's equitable share is calculated, and the buying spouse would need to secure financing, often through a new mortgage, to pay that share. This can be a good option if one spouse wants to remain in the family home, especially for the sake of children, but it requires the financial capacity to do so. In some situations, particularly when there are minor children involved and maintaining stability for them is a priority, the court might order a deferred sale. This means one spouse, usually the primary caregiver, is granted exclusive use and possession of the home for a specific period, such as until the youngest child reaches a certain age, or graduates from high school, or other agreed upon milestones. At the end of that period, the home is typically sold, and the net proceeds are then divided according to the equitable distribution principles that were established during the divorce. While less frequent, due to the potential for ongoing conflict and logistical challenges, the court could, in rare circumstances, order the former spouses to continue co-owning the property for a defined period. This might occur if there are complex financial situations or if it's seen as a temporary solution. However, as I mentioned, this often leads to further disputes and is generally not the preferred long-term resolution. It's critical to understand that the court's decision regarding your home won't just be based on who has a stronger emotional attachment or who wants to keep it more. They will meticulously weigh all the equitable distribution factors to arrive at what they genuinely believe is a fair and just outcome for both parties involved in the dissolution of the marriage. Navigating the complexities of equitable distribution, especially when your home is involved, is absolutely not something you should attempt to do alone. Consulting with an experienced divorce attorney is utterly essential. They can provide invaluable guidance in understanding your legal rights, accurately assessing the value of all your marital assets, skillfully negotiating a fair settlement agreement, and forcefully representing your best interest in court if a settlement cannot be reached. Your attorney will work closely with you to diligently gather all the necessary financial documentation, thoroughly understand the complete history of the property ownership and contributions, and strategically build a robust case to advocate for a fair and equitable division of all marital assets, with a particular focus on your home. Furthermore, they are uniquely positioned to advise you on the oft-overlooked potential tax implications associated with various property division scenarios. Remember, equitable doesn't automatically translate to a simple 50-50 split. The overarching goal is to achieve fairness, and what constitutes fair can vary significantly depending upon the unique circumstances and details of each individual divorce case. Gaining a comprehensive understanding of the specific factors that the Virginia courts will consider is the very first and most crucial step in proactively protecting your individual rights and your financial future. To summarize, Virginia follows the principle of equitable distribution, meaning marital property is divided fairly, not necessarily equally, based on a range of specific factors. The court meticulously considers numerous factors, both financial and non-financial contributions, the length of the marriage, the circumstances of the divorce, and the future earning potential of each spouse to determine a fair division. Your home is often the most significant marital asset and will receive careful scrutiny during the equitable distribution process. Understanding the fundamental difference between marital property that acquired during the marriage and separate property owned before or received individually is absolutely crucial as is recognizing how separate property can become commingled. Seeking timely and experienced legal counsel from a Virginia divorce attorney is absolutely essential to fully understand your rights, navigate this complex process efficiently, and vigorously protect your financial well-being. Now, I sincerely hope this more detailed explanation of equitable distribution in Virginia, particularly as it pertains to the disposition of your home during the divorce, has provided you with valuable clarity and understanding. If you're currently facing the complexities of divorce and have specific questions regarding your real estate holdings or other marital assets, please do not hesitate to reach out to me directly. My contact information is in the video description. Thank you for investing your time in watching Nova Real Estate Solutions today. If you found the information presented in this video helpful, please take a moment to show your support by liking this video and subscribing to the channel for more valuable insights into the intricacies of real estate and divorce here in Virginia. As always, please feel free to submit any questions you may have in the comments below, and I will make every effort to provide you with helpful responses.